Everyone, welcome to HOA Fight Club. I'm Raylene Schifano. Today I'm going to discuss the right to be heard and how things in the industry are affecting homeowners. The industry standards that are happening, that we are making major decisions on in our states, have affected the homeowners. The trades group or the trade standards are the professionals, the property managers, the attorneys, the construction, the banks, the insurance companies. All of those are our industry, and there's many different things, but there's different places in different states have their groups for property management companies. They all have their certifications. This is where their CAM certifications, their CCAM. I know there's a bunch of different kinds of certifications, but the industry standards and the trades groups are who sets the laws and do the lobbying, and they are the ones that are dealing with the legislators most of the time. Homeowners really don't have anybody that has represented them until really in my state the last couple of years, the last few years. There's people that, HOA Fight Club was started because of that. That's why I did the nonprofit. I wanted to make sure that somebody was a voice for the homeowners, and I felt like there was nobody listening to the homeowners and their fight for their rights. And I know that there's the constitutional battle, and we talk about that all the time. But when I went to court, and viewed a court this last few weeks ago, there is things being said in the courts that matter. When attorneys are going to the courts and they are telling the judges that, the board has the right to interpret governing documents, they have the right to amend the governing documents. This one attorney is only giving just a brief glimpse of what this association's responsibilities are. There are demands in this governing documents because there's a commercial property and a condo association that's on top of our commercial property. So there's a lot of things that go into these declarations to make sure that the commercial properties have rights, and so do the homeowners have rights. And if the commercial properties are affecting the homeowners or vice versa, there's supposed to be solutions in the governing documents for this. And the governing documents in this case do provide for those, but this board was trying to amend the governing documents and the rules and the fine schedule all at the time that they were trying to enforce these governing documents. Well, doing that required the vote of the majority of the commercial property owners. Well, the people that are being sued by the association for this fines and fees is actually the majority owner of the commercial property. So these owners had the right to vote, to amend governing documents. They have a right to be heard. They have a right to all these things when it comes just to the governing documents and the demands for the commercial owners. Then we add the opportunity and the right to be heard that is demanded by both the governing documents, the declaration, even the rules and regulations, and the law of the state. The right to be heard is demanded. Before you can fine anybody, you have to have the right to be heard. So if that right to be heard is denied, then anything after that right to be heard was denied should be null and void. And in this case, I do think the judge is seeing that. It's going to be really hard for a judge to rule that the association had the right to continue fining the owners for something that had actually come to a solution within 6 months for a commercial owner, and there was a solution that had come just because the commercial owner lost the tenant that they had that was causing supposedly the problems. So there's a lot of things that done. But if we go back to the right to be heard in that hearing could have solved a lot of different things. At that point, I was actually helping these homeowners or the owners, commercial owners, understand that, this is the governing documents, this is how they work. Homeowners don't know what the industry standard is. And so that was something that the attorney was pointing out. And the attorney on this case actually quoted, and this is quoting from the transcripts, is the fact that the whole point, what everybody in the industry knows. So the homeowners aren't part of the industry. So how do they know what the laws are? Now, we've given these associations the power of the municipality, and the attorneys and the property managers are the enforcers. They're the police force. So if we take away the right to be heard, and those that is just the basic right is to be heard, then we're actually that's the tyranny of government. That's the tyranny of these associations when they become the dictatorship of the homeowners. Now, I'm all about paying your assessments and being on time and making sure everybody participates, and the board should be treated as your mayor and the mayors, the vice presidents. Those are the kind of things that they should be responsible for. What the industry should be responsible for is maintaining fairness, maintaining that everybody is acting appropriately. If an attorney sees that an association isn't following the governing documents, that attorney should stop everything and say, wait a minute, time out. You need to have the right to be heard before we can add any fines. Instead, this attorney in this case just went to fining people without the right to be heard and denying the that right to be heard. So, and it only benefited her. The association, if they lose in this case, they're going to have to still pay those attorney fees. So the attorney gets paid no matter what. And the attorney is blaming the board. This is under the guise of, directors and officers. They're doing their best, whatever. But part of the board is a property manager, actually is sitting on the board. They are an owner. The property management company owns in this commercial property. So there's a lot of things going on that are being ignored and never even heard in the court case. But the one thing the judge understood is that the industry standards should not be defining the law. Everybody in the industry knows is not a very satisfying answer to me, was the judge's response. So that is really, really important, that judge understood that right. So again, I think that I'm hoping the judge understands that and takes those fines and fees. So if you take away the fines back to where they asked for the right to be heard and were denied, then how would you apply those attorney fees that were fining people for every 10 days? She was writing a 4-page minimum letter every 10 days. And let me tell you, the letters were just runoff copies. It's not like she spent another 5 hours writing a different letter. She just implemented the dates and the times difference and kept fining them and increasing her fees. If we're going to allow foreclosure for past due assessments, we have to draw the line when it comes to fines and fees. My state, they drew the line, but the industry standard is to still take advantage of that line. It's not about bringing the owners into compliance. It's about bringing the owners to their knees. This is what's causing our middle housing crises. You have, tenants that are constantly being evicted, and then you have owners that lose their properties because they can't afford the HOA dues and the mortgages, and these boards just get to push whatever they want. I agree with rules, but there has to be somebody that's governing the people that are making the rules. And the industry should be that standard. They should be reporting any board that's not doing what they're supposed to be doing. But the industry didn't figure out that it was better to make sure that the homeowners stay housed. They figured out that it is more profitable and beneficial to their industry to fine people into foreclosure, to force people out of their homes for a $50 fine, for a noise complaint, for a yard that's not been mowed right, with no due process. That is where it becomes unconstitutional. The government shouldn't be allowed to give away our constitutional rights in the guise of the industry standards and let the industry run it without any governance. Ombudsmen don't even understand this. They are listening to the industry because the ombudsman is the industry. The ombudsmen in these states are not there to make sure that the homeowners' rights are protected. They're there to make sure that the industry's rights are being protected. So if all we worry about is the industry and the trade standards and the industry standards, how do we protect the homeowners from the industry? And that is the problem that we're having. I mean, that is where it comes down to it. There cannot be anybody that has more power than our government. But these are rogue nations. These are HOAs is a rogue nation inside of each city, inside of each state. These little associations have a mayor, they have the president, they have the vice presidents, they have the treasurer, they have the secretary. That's your government. They should have the responsibility, the fiduciary duty, and the responsibility to act as a government. And the government should not be shirking their duties by allowing these associations to have the power to supersede our Constitution of the United States and say that you don't have the right to be heard, that they don't owe you due process, that the board can add rules and regulations whenever they want, that there's nobody watching the attorney who is not acting in good faith for the association, but is acting in good faith for what's best for her bottom dollar. We shouldn't be forcing homeowners to their knees. We should expect them to pay their assessments. I understand that. But the right to fine people, the right to add fees to somebody's account without some sort of governance and accountability, you're just asking for problems. I agree. These associations can run themselves. They can run perfectly, but there has to still be governance. You wouldn't allow the mayor to make decisions and then not have any accountability by the people. When you say that you have to have a 51%, you know, ownership show up to a meeting by person or proxy, sometimes that's an impossibility. Now, what if we did that in the government? What if to elect a mayor, we had to have 51% of the voters show up and vote? Would that happen? Would we have a government? We have just given these associations ultimate power by making the rules so tough, the bylaws so impossible to meet, that we have created a place where there can be a dictatorship and that we can have the tyranny of government because we don't even have the right to be heard. We need the right to be heard. We need governance. We need accountability. And it's not from the boards. We need the accountability from the trade industry. We need the industry standards to be above and beyond foreclosure. We need the industry standards to be keeping everybody housed. We need the industry standards to be fair, not selective enforcement, not to do what's best. I have one case where the attorneys and the property managers have decided that the special meeting of the ownerships couldn't even be called. And the one that actually all the owners participated in was null and void because it didn't benefit them. They are the problem right now. And I hate to point a direction, but if you want to fix things, you need to tell your legislators that the industry standards need to change. There has to be governance. And if we don't have governance, all we have is the tyranny of government in our own backyard. All right, you guys, I'll see you on the next one.